The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Horn. And good afternoon, everyone. Welcome to our virtual Court of Appeals oral arguments today. I just want to introduce our panel briefly. I'm Judge Donna Stroud, head of the panel today. And our other judges on the panel today, we have, I can't remember who's in the left and the right, but anyway, we have Judge Valerie Zachary and Judge Richard Gates. I have enough trouble with my left and right when I'm in the courtroom, so this makes it more complicated. But thank you for your patience with us today and getting our technical difficulties resolved so that we could get all this working well. So if anyone has a problem during the argument, just let us know, and our wonderful IT people here will try to assist us as they do every day. We have, as I said, one case for argument today, Julianne Stahl versus Daniel Bowden, and the appellants. We are ready to proceed. We have the timer here, of course, that's the timer in the courtroom. It's automatically set for 5 minutes of rebuttal, but if you would wish to change that time, just let us know, and Mr. Horn can adjust the time on the timer for the rebuttal. Otherwise, it is just automatically set for 5. So, for the plaintiff appellant, I'm sorry, the defendant appellant, Mr. Guy.
Yes, Your Honor, thank you. And good afternoon, Your Honors, and may it please the court, I would like to reserve 3 minutes for rebuttal.
Okay.
This case requires you to find that the defendant, Daniel Bowden, is entitled to immunity from the plaintiff's claims under Section 143B-1413 of the North Carolina General Statutes. That statute says that a 911 operator cannot be liable unless he or she engages in willful or wanton misconduct. Mr. Bowden was acting as a 911 operator or telecommunicator in this case, and there is no evidence that he engaged in willful or wanton misconduct. Thus, he is immune, and the trial court should have entered summary judgment in his favor. This court should reverse that decision. And the facts of this case, Your Honors, are not in dispute.
Can I interrupt you for just one moment, counsel?
Yes, yes, sir.
So in these, ordinarily, I have some questions to ask, and I would go back and forth with you in a series of questions and kind of build to the end. But in these remote arguments, I found that doesn't work very well. In fact, it's difficult even to interrupt counsel and get their attention when the court has questions. So I think I want to ask you one preliminary question that's not, I think the parties weren't discussing much in the briefs. And so I want to do it now if I let you get back to your argument. And I'm just going to lay it all out instead of walking through you with a series of questions. So in our precedent about immunities, the theory of why an immunity is immediately appealable is that the immunity is an immunity from suit. That's the way our case law describes it. So it's not just that you won't have to be liable and pay damages, for example, at the end of the case. It's that you have an immunity even to being hailed into court and called to account for whatever is raised in the action. So that applies both to the state, but also in public official immunity, for example, judges, prosecutors, police officers, various governmental officials have this immunity. And the idea is it's in order to ensure they can do their jobs, perform these government functions. The immunity means you don't even have to worry about being called into court to answer for this. And so my question is, there are, and I have some examples. So one example is in General Statute 166A 19.60, which deals with, this is part of the Emergency Management Act, so it's dealing with emergency responders. And this statute says it's called immunity and liability. It describes the immunities that the General Assembly is providing to these individuals who would not otherwise have had governmental official immunity. And in our case, we're dealing with a statute that doesn't use the word immunity. As you just mentioned, it says not liable for any damages in a civil action. So, you know, if I could go back and forth with you, I'd give you an example like medical malpractice and say, if the General Assembly chose to abrogate the common law of negligence for, let's say, doctors, and instead provided that doctors could only be liable for gross negligence, willful and wanton negligence, as is the case here, would we describe that change by the General Assembly as having given doctors immunity? And I think the answer is no. We would just say there's only one cause of action available in this fact scenario, and it requires the elements are willful and wanton negligence and not ordinary negligence. And so the question I'd like you to answer is, why is this an immunity that you can immediately appeal as opposed to just the elements of a cause of action that the General Assembly has permitted in this case includes willful and wanton or gross negligence, not ordinary negligence? And if in presenting the facts at summary judgment, the court you disagreed with the court's determination of whether there was a genuine issue of material fact there, like every other dispute about a genuine issue of material fact, you got to wait till the end of the case, a final judgment and appeal, and say that the court got it wrong. So what's your response to that?
Your Honor, it's a very good question. And as you know from having sat on the court for many years, and as I know from having practiced in this area of the law for many years, public official immunity or even governmental immunity or absolute immunity doesn't mean you can never come into the courtroom. I've litigated cases on public official immunity and governmental immunity all the way up to the North Carolina Supreme Court. You have to go through litigation. So the statute says that a telecommunicator cannot be liable. That is immunity. Now, does one really think that the legislature intended for a public servant, such as a dispatcher at a 911 center who makes maybe $35,000 a year, to go through a trial on the merits and wait for his personal or her personal liability and wait for a jury to determine whether they're going to apply jury instructions on a heightened standard of liability before it renders an answer? Or did the legislature intend to protect dispatchers from liability unless they acted in a willful or wanton fashion? Now, the question is, does this provide immunity just because the statute doesn't say immunity? Well, if you look at our case law, Your Honor, you will see numerous cases that do not actually use the term immunity in defining, for instance, public officials' immunity. Numerous cases will say, just simply, a public officer may not be held liable unless her conduct is malicious, corrupt, or outside the scope of his official or her official duties. That's public officials' immunity. Perhaps the statute should have used that word in there, but there's no other reasonable conclusion except that a telecommunicator cannot be liable unless there's willful or wanton misconduct. Willful or wanton misconduct is a question of law for the court to decide based on the facts before us. And as I said, Your Honor, earlier, the facts are not in dispute. And until you brought up that question, the law was not either, but it's a very good question. The only difference between the parties is whether Mr. Bowden acted in a way that his level of conduct rose to the level of willful or wanton misconduct. We believe that it clearly does not. And we believe that this court should give it full meaning to the legislative intent here, which is to protect these hardworking public servants from personal liability. He is sued only in his individual capacity here, unless his conduct meets this heightened standard. Now, the facts of this case are as follows. On February 7, 2017, a woman called the Pender County 911 Center about a down stop sign at Malpas Corner Road and U.S. Highway 421. Dispatcher Daniel Bowden, who is the defendant, took the call and told the caller that he would notify DOT about the sign, but he did not, and it appears that he forgot to do so. The intersection in question had a west side and an east side. On the west side, there were two stop signs. One of them was in the median, and one of them was on the right side of the road. And the one on the side of the road was clearly visible. The caller was referring to the one in the median that had been knocked down. But as I said, the right stop sign was still up and visible. If you will look at the video of the accident, which was attached to the sheriff's affidavit and is in the record, you can see the stop sign plainly visible. The east side of the intersection, the opposite side of 421, which the plaintiff did not go through, also had one stop sign, and that was on the right side of the road. By law, the intersection only required one stop sign on each side. This was the testimony of the regional traffic engineer for DOT, and it is in Section 2A of the Manual for Uniform Control of Traffic Devices, which is incorporated by statute as our state law and sets the standard. Now, the second stop sign that was on the median, in the median on the other side of the road, or the side that Mrs. Stahl went through, the plaintiff, that was only a supplementary sign. 3 days after that woman called the 911 center, Mrs. Stahl was heading east about 5:17 p.m. on Malpas Corner Road and approaching US 421. She was heading east, so the sun was not in her eyes, it was to her back. And in the 8 minutes before she enters the intersection, according to the video, 5 cars in front of her on her side of the road stop at that stop sign. And on the other side of the intersection, which is a mirror image, 17 cars stop at that one stop sign. So in the 8 minutes prior to her going through the intersection, 22 cars stopped. Mrs. Stahl, as you will see on the video, came up to the stop sign and didn't even stop. She blew through it without stopping, and she collided, unfortunately, and this is a tragic case, with an 18-wheeler that was headed north on US 421 out of Wilmington. That was to her right. The vehicle was heading north, which was to her right.
Counsel,
She was seriously...
Can I interrupt you one more time?
Yes,
just to, again, try to narrow the issues. You agree that those actions have no... The facts you just described about how many other cars stopped at the stop sign, completely irrelevant to the question of immunity. Do you agree with that?
Yes, I agree with that, Your Honor, but as you will see in my briefs, I have asked the court to look at, within its discretion, other issues, including contributory negligence and superseding and intervening negligence, and that is why I've discussed all these facts.
Okay, I just wanted to confirm, because of course, what you're asking us to do there is exercise essentially pendant jurisdiction over these other issues for which you would not have a right to an interlocutory appeal, and we typically don't do that. So I just wanted to get you to confirm that. So we're solely focused on the question of immunity in terms of the...
That is correct. That is correct, Your Honor, and that is within your discretion whether to address those issues. Now, Mrs. Stahl, as I said, the facts were she was seriously injured and her husband was killed, and she was cited by the North Carolina Highway Patrol for running the stop sign. She filed a lawsuit against DOT for not replacing the sign and against Mr. Bowden for not calling DOT. Now, one important fact that was left out of the plaintiff's brief that the court should address is that the sheriff of Pender County, Carson Smith, who is the former sheriff, he was responsible for operating the 911 center, and he stated in an uncontradicted affidavit that telecommunicators in the 911 center were not required by any local policy or state law to notify DOT about down stop signs. And if they did so as a courtesy to the public. Obviously, the sheriff sets the policy for the 911 center, not the plaintiff. And the DOT regional engineer said there was no agreement between the sheriff's office and DOT for the 911 center to notify it about down stop signs or traffic signals. In fact, in 7 years on the job up to the point that he took this call, Mr. Bowden had never received a call about a down stop sign before. Now, the 911 center dispatches for police, fire, sheriff, and ambulance services, but not for DOT. It does not even have a module in its computer-assisted dispatch system for DOT. It has an on-call number that dispatchers can call after hours, in which, if they need to, but it has no authority over DOT, and it has not one single iota of authority to dispatch for DOT. Those are the facts, Your Honors, and the argument here is, number one, there was no willful or wanton misconduct. So the question the court must look at is, what is willful or wanton misconduct? Well, our cases talk about willful or wanton conduct. And willful or wanton conduct is defined in various ways. Willful and wanton conduct is the same as gross negligence. Gross negligence is wanton conduct with conscious or reckless disregard for the rights and safety of others. It is more than negligence. Wanton conduct is of wicked purpose or with reckless indifference to others. Willful negligence is done purposely and deliberately in violation of law or knowingly out of purpose. Willful conduct involves deliberate purpose not to discharge some duty imposed by contract or law. Wantonness requires intentional wrongdoing. Negligence becomes gross negligence when the injury or damage itself is intentional. Thus, we clearly have a higher standard for willful or wanton conduct than mere negligence. And the statute says misconduct, not just conduct, which further elevates the required conduct beyond mere negligence. Now, how do these descriptions fit into this case? Green versus Kearney, which is a decision of this court from 2011, provides a perfect example. In that case, a man was found on the side of the road one night and emergency responders came to the scene. 8 people saw movement in the man's chest and abdomen, but the medical examiner declared him dead anyway. He was taken to the morgue and the medical examiner EMTs again saw movement in his chest and abdomen, but they ignored it and put him in cold storage for dead bodies. Only when a state trooper came to the morgue 90 minutes later and asked about the man's injuries, and the medical examiner pulled the man back out and he moved again, did anyone realize that he was not dead. This court said that was not gross negligence. That was not willful or wanton behavior. The EMTs were immune under a statute that said they could not be liable unless they committed gross negligence, wanton conduct, or intentional wrongdoing. In other words, the same standard here, just with slightly different terms. The court had previously dismissed the medical examiner on public officer's immunity because he was not malicious, corrupt, or acting outside the scope of his duties. And this court said in that case that the difference between ordinary negligence and gross negligence is substantial. The most important factor was whether a defendant's acts involved intentional wrongdoing or deliberate misconduct affecting the safety of others. The court said the EMTs had engaged in carelessness of a very high degree of magnitude, but it was not enough because they did not know that the patient was alive when they failed to provide him medical assistance. The message of the Green case is that it might have been a good idea to check on the plaintiff to see if he was alive because he kept moving and appeared to be breathing. But the defendants, who were trained medical professionals, did not do so. If that is not willful and wanton conduct, then Mr. Bowden's failure in this case to make a call to DOT definitely is not. There is no evidence that he deliberately failed to call DOT, if he even had a duty to do so. The only evidence is that he forgot to call DOT. He did not act deliberately, wickedly, needlessly, or recklessly, or in conscious disregard of others. Now, the courts have also defined misconduct as requiring improper and wrong conduct, done intentionally, knowingly, and generally in bad faith. Black's Law Dictionary defines misconduct as requiring improper or wrong behavior, but not negligence or carelessness, which, for the sake of argument, we might have here. Nothing Mr. Bowden did approaches any of those definitions of willful or wanton misconduct. At most, he forgot to make a phone call. But the evidence is that he did not even have a duty to make it because the 911 center was not required to call DOT. Now, Your Honor. Yes, Your Honor.
If the defendant undertook to call DOT for the caller and for the public, is he showing a conscious disregard for the safety of others? If he has knowledge of his duty or voluntarily undertakes that duty?
Well, Your Honor, that assumes a duty, and the sheriff provided uncontradicted evidence that there was no duty on behalf of 911 dispatchers or telecommunicators to call DOT. You might be leading into whether there was an assumption of duty or a voluntary undertaking doctrine. Is that correct?
Yes.
Your Honor, the question is whether he assumed the duty. No, but even if he did and he breached that duty, his conduct was simply negligence, not willful or wanton misconduct. When we ask about a conscious disregard of a duty, let's assume that there's a duty to begin with. Mr. Bowden was not given any training materials. There is nothing in the record to show that he received any training materials. There is nothing in the record to show that there was any written policy or law that required a dispatcher or telecommunicator, we use the terms interchangeably, to call DOT. So if there's nothing there, but simply a practice of a courtesy to the public, and he had never received a call like this before, he cannot have consciously disregarded his duty. Now the question is, did he assume the duty by telling the woman on the phone that he would call DOT? Again, even if he did, it's simply negligence to forget to call. The case that is appropriate to that issue is Lampkin versus Housing Management Resources, a decision of this court from 2012. The court said that that doctrine applies only when a party actually engaged in some undertaking and not just says that he or she will do something. The facts of that case are as follows. An apartment complex had a playground with a fence around it. The fence had a hole in it. Children were going through the fence to get to adjacent property. There was a pond on that property. Someone told an employee at the apartment complex about the hole, and the employee said that they would look into the matter, meaning the apartment complex. One winter day, the pond froze over. A 4-year-old girl went through the hole in the fence and walked on the pond. The ice broke. She fell in, and she suffered permanent brain damage. She sued, and the court said the employee's assurance that they would look into the matter was not enough for the apartment complex to have assumed the duty to fix this fence, because the apartment complex did not take any steps beyond this. This is akin to walking up to someone on the street who may be an old man or an old woman and saying, I will help you across the street. Until you start helping that person across the street, you have not assumed the duty. You're just saying you will. Here, Mr. Bowden did not do anything except say he would call DOT. He did not try to call DOT and then give up. He did not call DOT and not report the down sign. He just forgot to call, which again is simple negligence. He did not assume, thus, the duty to get the stop sign placed back up. It was a duty he did not have in the first place. So the assumption of duty doctrine does not apply in this case, but even if it did, it is still not willful or wanton conduct. Does that answer your question in a long way, Your Honor?
Yes, it does. Thank you.
And Judge Dietz and Your Honors, I'd like to talk about the interlocutory issues briefly, if I may. The contributory negligence argument, it's within the discretion of the court to address. Mrs. Stahl admitted that she had a duty to stop for a stop sign if there was one there. There was one there, and she did not stop, which is why she was cited. There's other evidence of lack of due care there. She did not yield to a car coming or a vehicle coming from her right. She did not yield to the traffic on a dominant highway. She was talking on her phone and using a GPS device while she was driving. And that bars her claim. It does not bar the estate's claim. The estate's claim, however, is barred by intervening and superseding negligence. And one case, Coleman versus Ruddisville, is very instructive because in that case, the property owners were negligent, but the court held that they were not liable because of the intervening and superseding negligence of a third party. In that case, the property owners left a leaky paddle boat on the shore of a pond. Again, a pond case, and children are involved. It was an attractive nuisance. An adult man who was deaf and mute took several children to the pond, and they swam, and then they took the boat out on the pond, and the boat took on water and capsized. 3 children and the adult drowned. But the court said the property owners, even if they were negligent, were not liable because any negligence on their part was superseded by the intervening negligence of the adult who took the children out on the pond. Just like in this case, Mrs. Stahl's failure to stop at the stop sign is the cause of her husband's death. Any negligence of Mr. Bowden is superseded by her negligence. And again, we were talking about negligence of Mr. Bowden. Your Honors, the big picture here is this. The legislature enacted a statute to protect public servants such as 911 telecommunicators who do a hard job for little money. And that statute says they cannot be liable for doing their jobs unless they act in at least a grossly negligent fashion, willful or wanton misconduct. Now a driver who ran through a plainly visible stop sign is suing him personally because he did not notify DOT that a second stop sign, which was not even required by law to be there, was down at the intersection, even though the driver was in no way relieved of stopping at the stop sign that was up, and even though Mr. Bowden did not have a legal duty to call DOT in the first place. He said he would, but if he did not do so, then he was merely forgetting to do so, which is simple negligence at best.
Counsel,
Now, what if that woman
can I
had
interrupt
never
for
called
1 second? I find your contributory negligence argument pretty persuasive. I think the argument we're going to hear from your friend for the plaintiff, and the question that this court is going to ask is, almost every calendar we're asked to entertain appeals by, in a civil case, from a defendant who filed and lost a motion for summary judgment on contributory negligence and is jumping up and down screaming, it's so, this is obviously there's no genuine issue of material fact. We should win as a matter of law. We're going to have to go through this whole trial, and then we're just going to get up here on appeal and win later. And this is a huge waste of judicial resources. Please just hear this appeal so you can correct this mistake by the trial court. And we dismiss every single one of those cases because the rule is that cost and the burden of the trial is not something that permits an interlocutory appeal under our precedent. So what about this case is different from just the mine run case where we're asked to do precisely what you're asking us to do here?
Well, Your Honor, I concede that the contributory negligence argument doesn't make this case any different from any other case that you've just described. But this is different. This case is different because we're talking about a public official, a criminal justice officer by statute who serves the public at large. The public duty doctrine does not apply because he was not performing a law enforcement function as a 911 operator. Governmental immunity doesn't apply because he's not sued in his official capacity. Public officials immunity might have applied, but we didn't argue it below, even though he's a criminal justice officer by statute. So we're left with a statute that says he cannot be liable. I don't see any difference between saying a law enforcement officer cannot be liable unless his or her actions are malicious, corrupt, or outside the scope, and a statute that says a public dispatcher cannot be liable unless his or her conduct is willful or wanton misconduct. So it is an immunity from suit. And if every 911 dispatcher were sued across this state for every phone call that they didn't have a duty to make, but they failed to make, that would clearly discourage public employment for a job that pays little money as is. So this is a different case because there isn't an immunity. There is immunity. The legislature was not clear, perhaps, in its statute, but its intent was clear. The words were not clear, but the intent was clear. So Mrs. Stahl has sued someone because she ran a stop sign who has a tangential relationship to her case. Telecommunicators at 911 centers, as the testimony in the deposition shows, deal with all kinds of emergencies every day, affecting police, fire, and ambulance service. They work nonstop during natural disasters such as hurricanes, but they are not the insurers for everyone's well-being, and they may not even, they are allowed to make a simple mistake. They may not work completely mistake-free. Once in a while, they can make a mistake. The legislature recognized this in the statute and said, we're going to place this position beyond simple negligence claims and say willful or wanton misconduct is required. And as I said earlier, Your Honor, there are a number of law enforcement officers that I've represented over the years and that you've seen come through the courts who have gone through all manner of litigation before the court finally says there's immunity. So it's not a bar to enter the courthouse door to have this immunity defense. You have to actually litigate it.
Guys, you're at your 3 minutes. Just wanted to make sure you realize there was a little yellow light.
Yes, ma'am. Thank you. 246, I think I have. So this is what this statute.
So if you want to reserve any time for rebuttal, I'm just, that's your time.
Yes, ma'am.
Okay.
So this is what this statute is about, and you should give effect to it by reversing the trial court. Mr. Bowden may have forgotten to call DOT, which he was under no duty to do in the first place, but that is not willful or wanton misconduct. And if Mrs. Stahl had stopped at that stop sign, we would not be here. I'd like to reserve 2 minutes and 16 seconds for rebuttal, Your Honors.
Very good. Thank you. All right. For the appellee. And we cannot hear you right now. Make sure you're not muted.
Hello?
Yes, we can hear you now. Well, now we can. Wait a minute, Mr. Collins. We can't hear you.
Can you hear us now?
I hear you now, yes.
Good, sorry. And Mr. Baker's the lead counsel. I'm letting him take over.
Okay, I'm sorry. We have the other name on our screen, so thank you. All right, we'll start now. Okay.
Are we okay now?
Yes, hear you now. Good to go.
If it may please the court, we're here today representing Miss Julie Stahl, who was seriously injured in this tragic accident. And also we're representing her as executive of her husband's estate, of course, who passed away, and the 5 children for Mr. Stahl. The facts, the basic overall view of the wreck are certainly not in dispute. In fact, it's very unusual that you have a video, tragically, showing the wreck. And it was part from a security camera that was there. Also, certainly, it's true this is interlocutory, and we're limited to this question of immunity. Judge Deeds, as you can tell, I didn't think of your argument there, but it certainly makes sense. The legislature could have said and used the words immunity instead of simply limiting or setting a standard for liability as they do for many people. The statute of 143B-1413 is clear, and it is set the level of proof that we must have of the wanton or willful misconduct. There's been some discussions that maybe that the defendant, Mr. Bowden, was a justice officer, and referrals in the brief and the reply brief to 17E-2. That is a concerning education in the Sheriff's Department, and for that purposes only, it talks about a justice officer being and including the 911 operator. So we say that I think it's very clear that the later statute of 143B-1413 specifically addresses issue, and it should be applied in this case. If they wanted different language, they certainly could have put it there. And if they wanted immunity, thank you for pointing that out, they certainly would have put it there. We also are very fortunate that we have been able to have the actual basis of our lawsuit, which is the 911 call, the transcript from February 7th, 2017. And before we go through that in detail, I first want to remind you, and it's something to think of as you're looking, the caller simply identified an emergency, a dangerous intersection without a stop sign. It did not suggest at all DOT, but presented to the 911 operator, the defendant, hey, we've got a danger. You handle emergencies. She called the Sheriff's Department. And what did he say was, I'll call. He made the election instead of calling the police to secure the intersection. He said, I'll call DOT. So that was not the caller asking him to do something that he had no duty to do. His duty was to handle emergencies from people in the community. And he got a real emergency. Let's go over for just a minute that transcript. If we could see if we can pull that up. Can everyone see that?
Yes.
Okay. And again, this is a call to the Sheriff's Department. Hey, I'm sure someone probably is aware of this already, but the stop sign at Malpas Corner and 421 is down. It doesn't say for which direction. In fact, it says the, not a. It looks like maybe there was an accident there today earlier or something, but that's a dangerous intersection for there not to be a stop sign up. So stopping right there. The call was not about DOT. The call was about we have got a dangerous intersection. And we know it happened a little after 5 o'clock in February. time when, of course, the sun is getting ready to go down. The caller, that's the defendant, said, when she said, yes, ma'am, you said Malpa's Corner, 421. Answer, it is. Yes, sir. And I don't know if there's anything that can be done at this time of day. I just wanted to bring it to someone's attention. Bring to their attention this dangerous intersection for there not to be a stop sign up. Operator, all right. We will definitely let DOT know. Thank you so much. Caller, you're welcome. Goodbye. Now, we'd like to play that just so you can hear the inflections of the voice.
Kearney County Sheriff's Office. Hey, I'm sure somebody probably is aware of this already, but the stop sign at Malpa's Corner and 421 is down.
Okay.
It looks like maybe there was an accident there today earlier or something, but that's a dangerous intersection for there not to be a stop sign up.
Yes, ma'am, it is. That's Malpa's Corner, 421.
It is, yes, sir, and I don't know if there's anything can be done this time of day, but I just wanted to bring it to somebody's attention.
All right. We will definitely let DOT know. Thank you so much.
You're welcome. Bye-bye.
Bye-bye.
All right, we're going to take those down now. All right, so clearly, when you listen to the inflections, when you listen to the statements, this is a caller who was concerned about an emergency. Everyone, including the defendant, his supervisor, and the experts, say a call about a down stop sign, and particularly as it gets dark, is urgent. It's dangerous. It's a problem. Now, I'm certainly no expert about what you do when there's a down stop sign. So, of course, what do all lawyers do? We go hire experts who've been in the field. Mr. Robert Pusins has been in the field for almost 30 years down in Florida, handled large call centers, some 20-some different communities. He reviewed all this. He reviewed the different documents. He reviewed the calls. And so we make sure we get over this point, talked about the standard of care. Now, I agree with Mr. Weiss when he made the opinion that this constituted willful or wanton conduct. That was going to the legal conclusion, so I'll withdraw. I don't think we can go that far, but certainly under the Green versus Kearney case and others, the information that was included concerning standard of care from an expert is clearly admissible. I have no idea. I don't think most of us have an idea of what do you do if you're in a 911 and someone says, hey, the stop sign is down at this intersection, and you know how dangerous it is for there not to be a stop sign. So the expert's opinion on standard of care. You have got an emergency. You have got an urgent situation. What do? You can send out law enforcement to secure it. Find out what's wrong, secure it until DOT can get there. Secondly, at a minimum, call DOT. You know there's an emergency, so do something about it. Now, when he talked about duty to dispatch, of course, the 911 operator had a duty and the opportunity and the authority to dispatch police. So we have no argument about that. So the only evidence about the standard of care from experts in the field is that you take care of emergencies when you're told of a dangerous intersection without a stop sign. Now, of course, the other side has argued there were two stop signs. But we asked the defendant, did you know? First, which way they were talking about? He said no. And second, did you know there were two stop signs? He said, no, I didn't know that. So it couldn't have been, the only thing he had was in that the stop sign was down and this was dangerous. So the evidence before the court, taken in the light most favorable to the plaintiff, on the motion for summary judgment, certainly raises a genuine issue of material fact as to the standard of care for a 911 operator who received that call.
Mr. Baker, if I could just ask, so you're basically saying that you've got a dispute with the defendant, of course, about the existence of the standard of care based upon, I'm just trying to define, I mean, where are you getting the standard of care from if the policies of the Sheriff's Department did not require it, if no statute requires it, if there's no law that would require him to notify DOT, where is that coming from? Where's the duty coming from?
All right, that would be from an expert in the field. We all call in people who do this all the time.
Sure.
You know, you have to come to see.
The legal duty, where does that come from? I mean, where is he getting it from? I mean, I think everyone would agree that we certainly wish he'd called and had done that. But legally, where's the duty coming from?
Okay. Simply the creation of 911 centers, that they are empowered to accept these calls from the public. And so then they are given the duties to dispatch them and the authority to dispatch. They're always there. Certainly, this would not be an argument if they said, can you send the police out here? He certainly, and didn't do it. That would be a breach right there. He said he was going to send the police. There's no question he has the right to send the police out there. So that's how while they were created, as I understand, 911 operators. And certainly there's standards all across the country. And while I didn't know it, I tried to find the experts that would help us to establish that standard. Now, also there's a practice they had in this center where they said they didn't have a duty. They assumed a duty. They did it all the time when people would say, I have a problem, we'll take care of it, because, and the reason for this assumption of duty is because that caller who's all upset, a dangerous intersection, all the defendant had to say was, ma'am, that's not our duty. You call them yourself, or here's a number, you call them, and then all likelihood, someone that upset would have called. But what did he do? He assumed the duty so that she then could rely upon him. He did an activity of, I'll look at, he said, no, I will call DOT, he made the decision. So that's also the assumption that we have. And we know of this process and that it works because we have the second call. If we can put that back up. The same person that relied upon the defendant and didn't call herself. Yes, could you tell me if anybody's on call at DOT on the weekend? You have to know that by chance. Operator, we have on-call person we have to call for emergencies. So right there, we have testimony from a fellow 911 operator that says we have this process. Not just DOT has somebody, we have an on-call person we have to call for emergencies. It's on the back wall, they all testified. They do it frequently or said they've done it. So it's right here. The caller comes back. Well, I mean, there's a stop sign down at the intersection of Malpas Corner and 421. Operator, yes, ma'am. Caller. And I called earlier this week, and they still haven't come to put it back up. And someone was killed at that intersection last night. Operator, okay, we'll notify DOT for you. Caller, thank you. Operator, you're welcome. And again, the inflection of tones, I think, is important if we may play this.
Yes, could you tell me if anybody is on call at DOT on the weekend? Do you happen to know that by chance?
We have an on-call person. We have to call for emergencies.
Well, I mean, there's a stop sign down at the intersection of Malpas Corner and 421.
Yes, ma'am.
And I called earlier this week, and they still haven't come to put it back up. And someone was killed at that intersection last night.
Okay, we'll notify DOT for you.
Thank you.
You're welcome.
All right, and what's important about that call is that the stop sign was put up within 2 hours. They had the person for emergency. They had the number on the board behind. Everybody knew about this procedure. Now the question is, so we had the duty to dispatch police. We had the assumption of duty. And one of the cases that we talked about here was the apartment case with the fence, where they said they'd look into it. This was interesting because it was actually the owner of the pond that the children were going to play in who came to the apartment saying, you've got a hole in your fence and your children from your apartment are coming to play in my pond and it's dangerous. Well, if there's ever been a better case for attractive nuisance, I haven't heard about it, than that owner that put up their own fence or whatever else. And so the court was saying it's not the duty of the apartment building to keep in their residence. And they didn't assume the duty because they just said, I'll look into it. This is totally different from our case. By the actions of the defendant, he in effect prevented the caller from doing her own thing of calling DOT. If the defendant had merely said, ain't my duty, ain't gonna do it, you gotta call yourself, what do you think would happen with some of this upset? We don't know, but that's the reason we talked about assumed duty, because then you rely upon the people. But let's talk about then the willful knowledge.
One of the things that I heard, you sort of synthesized some of the key arguments for your friend, for the defendant. And one of the things that I hear and that I think the court is concerned about in this case is how we limit the scope of a potential holding in your favor in this case. Because by the very nature, every call to 911 is going to involve some emergency where it's likely that if things aren't handled correctly, severe injury could result. You're talking about fires, crimes, all sorts of things like that. And so you can interpret what the legislature has done here as said, even though we know there are these risks in every case where a 911 operator mishandles the call, we're going to create this heightened burden of willful or wanton, essentially gross negligence in order to have liability. And what happened here, it's hard to see this as anything other than just bureaucratic ineptitude. And if that's enough, aren't we just eviscerating what the General Assembly wanted to do here, which is to make it so that only there's almost a level of intentionality required in order to say that you'll hold these 911 operators responsible? So what's your answer to that, which is almost a policy argument that's coming from your friend for the defendant about this case?
Well, certainly we all are responsible for our actions, and the legislature put a little higher standard for their level of mistakes. It can't be we're all liable for our own. Well, the test comes about knowledge. Y'all have looked at the case of Green versus Kearney, where the man was dead in the road, or they thought was dead in the road. And they went to Illinois and looked at 3 cases to decide the willful and wanton. We first look at what was the knowledge that the 911 responder or the EMT had, then how did they act with that knowledge? And they looked at 3 cases. One, a person was dying, had asthma, called, said they had an asthma attack, thought they were dying. They responded, knocked on the door, no one answered, so they left when the door was unlocked and the person died. The second one, they had a victim on the stretcher. They didn't secure the legs, didn't secure the person on the stretcher, let go of the stretcher, hit a pothole, flipped the person off and killed them. Third was a victim had some type of an allergic reaction. They could see they had trouble breathing and waited 7 to 8 minutes to administer the drugs. All 3 of those, they had knowledge and yet didn't do anything when they had it available to them. Something happened here because the defendant says he doesn't remember a call like this. He admits that his supervisor took him into a closed door to talk to him about this situation. And when I asked him about it, and the supervisor, maybe you read in there their answers, they couldn't remember. And they couldn't remember the conversation about what he had done wrong because I was asking the question, and they couldn't remember what in the world they talked about there. So the asthma victims, they knew the person had asthma. We knew a stop sign was down. She said she thought she was dying. We knew how dangerous this intersection was. They didn't open the door. We didn't pick up the phone like we had done and called DOT before on other situations involving intersections. They put a victim on a stretcher when they knew it wasn't right, when they weren't tied down, and let it go, hit a pothole. Omission. Next, they had a victim with allergic reaction, and they didn't administer the drug. He knew in a dangerous condition. What's foreseeable? What is foreseeable is getting there dark. It's in the country. You have a stop sign down at a dangerous intersection. What is foreseeable? A wreck. I mean, that's exactly what you think is going to happen. That's the reason you have stop signs up in the first place, is so we don't have wrecks. So the test in Kearney is knowledge, which we've got, and his actions. Now, remember, there is no excuse by the defendant. He doesn't say. We went back in the records. I had all these calls. I had a murder. I had all these things happen. He testified. I always write down my notes. I always make sure I make all my calls at the end of the day. It's about the end of a shift. I tell the next person, this is my job to do this. And he said it. I'm going to do it. Wow, you've got an emergency. You have everything at your fingertips. The police, anybody to send out there, or call DOT. It would have been 3 days before this wreck happened. We know it takes them 2 hours to put up a stop sign, and when they did call, it was put up. So that's the reason we're saying the test that North Carolina's adopted under Green versus Kearney is knowledge and what they did with the knowledge. And again, I think what I argue, taking in the light most favorable to the plaintiff, this is a conscious disregard. You just tell me something's dangerous, I hang up the phone. I don't make a note. I don't call. I don't do anything.
Is it your argument then that knowledge is the equivalent of intentionality?
If you have knowledge and do nothing with it, was found to be willful or wanton under Green versus Kearney. I mean, it's not, you're not going to be locked up for civil. Locked up for criminal activity. No, I don't think he said, I'm just going to intentionally see if somebody will die. We can't say that, but he certainly didn't care enough. It's a reckless indifference to the safety of others. If one of us got that call and we were sitting there in 911 and we got that same call, would you really do nothing? If I could just talk to the people on the jury, I certainly think that, and our whole test is, do we have a genuine issue of a material fact? We consider that the evidence about the standard of care is here, and the defendant offers no evidence of why he didn't do it. No excuse. It wasn't we got busy. It wasn't I'm a great servant of the public, and I had a big cause about a gunfight at the school. No, that wasn't it at all. So going by the law of the Green versus Kearney about knowledge and lack of, those three instances it showed, this certainly fits this case. It's knowledge and then the reckless disregard the safety of others. I thought I saw another question. But let's talk a little bit about, well, also, we do object to going into anything other than the, quote, immunity, if there is one, by the statute. Just now that you mentioned it, it certainly does not say immunity, and then we would object to going further than that. But as we're looking at the issue of how in the world did this wreck happen, that's where our other expert came in play, Mr. Dean Morrisseau, who is a great action reconstructionist, particularly signs, and he actually drove the route. And he said, you know, for 19 intersections that Mrs. Stahl would have gone through, she was on the dominant road on all but one, the first one. And at that intersection, there was flashing lights, stop ahead, stop sign and supplemental stop sign, junction ahead, and she knew she had to stop. On all the other 18 intersections, she didn't have to stop at the intersection if she was on the dominant road. What makes this intersection at Highway 421 in Malpa so unusual? There wasn't one of those little orange signs with the cross arms like that saying intersection. There was nothing saying stop ahead. You'll be glad to know. No, now there is stop ahead, which is good. There was nothing of that. There's nothing about intersection with 421 ahead. There was nothing about Fayetteville to the left and Wilmington to the right. There was zero. And that supplemental sign had been placed there because it was needed. There was engineering and crash history. As the engineer said, DOT, we don't put it there unless it's important. And it's important because as you come up, there's no other signs, period. No flashing, no nothing. This is all it's going to be is that little sign on the right-hand side. And because of crash history, we put another sign in the middle of the road, in the concrete median. Because that's going to be staring you right at the face. Now, the facts of this case, our lady's going in a 55-mile-an-hour zone. It's going 40. The black box says she's coasting. Doesn't have her foot on the brake or the gas. She obviously is going slower, can see it's an intersection. But she has been on the dominant road. Does she have to stop or not? She doesn't see. You can see what's going on here, that she is coasting. This is a lady with no history, no criminal history, no driving history, No wrecks in 30 years. Not in a hurry. It's a clear day. There's no reason this lady would run the stop sign other than she didn't see it. The opinion of our expert says you become accustomed to, you get reinforced that if you need to stop, bells and whistles, rumple strips, signs, lights, that tells you ahead, stop ahead. Now, it's not required, except DOT said in this case, not required by law, but DOT said you do need a supplemental sign, and that's the one that was knocked down. And that was really important, according to our experts, because that'd be the one staring you in the face. She could not have missed that sign, and therefore it was very important. And is that conditioning you get on strange roads when you don't have to stop unless there's bells and whistles telling you to, that had conditioned and reinforced for her that she was on the dominant road. So we understand now, after we went through it, and remember, she was charged, and after investigations, the cases were dismissed, and they were expunged. And at the end of it, we went through a process where it was a deferred prosecution and ultimately dismissed. So those were behind us on that too. So we understand from our experts that this sign was vitally important. Its absence was vitally important because it was determined necessary. In fact, afterwards, like I said, they put up other warnings, which was good. But a very unusual intersection, and one that we haven't seen like this in a long time. Our original actions, of course, were against DOT because we thought they'd gotten the call. We thought 9/11, of course, they called them. And so we said, you got that call. And then we found out that for absolutely no reason, the defendant did not make the call. For contributory negligence, again, we object to you getting to it, but it's irrelevant. If the defendant was guilty of willful or wanton negligence, then contrib is irrelevant. It's not a bar. We all know that. Gross negligence, of course, it's not the defendant's simple or plaintiff's simple contrib is not a bar. So that's not that the law is clear, but again, we object to hearing that. Then intervening negligence, again, we object to that, but there's some very good cases about foreseeability. We cited a case where they didn't put the lug nuts on right. The tire came off, individual stranded on the highway. A minute and a half later, a truck comes along, hits them and kills them. Of course, they were negligent. They said the original one where they not put the lug nuts on right. Hey, you could proceed if you didn't put them on, somebody gets stranded and it could be on the highway. And so that, again, it's for the jury. So we say to you not to go to those other issues, but they certainly are for the jury. So the court, trial court, of course, listened to all this argument, listened to what was actually said, and felt like there's genuine issues of material fact. The duty, of course, to send out the police to secure the intersection, or assuming a duty to do things so other people don't do it. You've changed things, and then offering no excuse, no reason. I just can't remember as a supervisor. I just can't remember. Well, I don't think a jury is going to buy that. And this is pretty, again, don't we have a genuine, an issue of genuine fact? Certainly, we have experts that talk about it. Common sense talks about it. Listening to it certainly raises, and the trial judge ruled this way too. So we really believe what we have done is, the trial court listened to everything. We'd like to go forward with this case, of course, for the family, for the estate. It was clearly avoidable. It's understandable now when you really listen to the experts and what was wrong with that highway, which is now being changed, that this can happen to any of us when we're in strange places. And the contrib does not bar when there's gross negligence involved. Knowledge, this case rests on knowledge, and certainly the defendant had knowledge. Thank you very much.
Thank you. All right, rebuttal. Mr. Guys, can't hear you. Make sure you're not muted.
Yes.
Okay.
Can you hear me now?
Yes.
Can you hear me?
Yes.
Okay. Your Honors, this is a case of first impression. No court of ours has addressed or applied this statute on the appellate level before. But let's give the meaning to what the drafters of the statute intended. a 911 telecommunicator may not be liable unless his or her conduct was willful or wanton misconduct. Now, the question is, was there a conscious disregard of a duty here? First, let me note that Mr. Bowden does not remember this call. So whether he knew there was a stop sign up at that intersection or not is, not really in evidence because he doesn't remember one way or another. But how can this be a conscious disregard when, in reality, there was a stop sign up at the intersection controlling traffic? We're operating through this entire case under this fiction that there was no stop sign, that Mrs. Stahl didn't have to stop at the intersection when she plainly did. The duty for putting stop signs up and repairing them falls to DOT. The court said so in Reed versus Roberts. It does not fall to 911 dispatchers. The intent of the legislature in drafting this statute was to protect dispatchers from being harassed from these lawsuits, these very types of lawsuits, unless their conduct was egregious, willful or wanton, not simply negligence. Your Honors, for these reasons, and this will be a case of first impression, but for these reasons, you should give effect to the purpose of the statute, which is to protect telecommunicators. If the legislature didn't want to do that, it wouldn't have enacted this statute. And we urge you to reverse the trial court for that reason. Thank you, Your Honors.
Thank you. Thank you all very much for your arguments, and we will adjourn court virtually.
This session of the North Carolina Court of Appeals is now adjourned.